All rise. The Court of Appeals entered for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Emander, Chief Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral arguments at the 5th District Court of Appeal. I've already been introduced. Let me introduce the other panel members. Seated to my right and your left is Judge Eric Eisnagel, and to my left and your right, Judge Meredith Sasso. We have 5 cases scheduled today, 1 criminal, 4 civil. In each case, each side will have 20 minutes for oral argument. The appellant is entitled to divide that time between an initial argument and a rebuttal argument after the opponent has spoken. So, when you come up here, I'll try to help you if you tell me how much time you wish to reserve for rebuttal. Now, the second and third cases, we have a cross appeal, so I'd ask the attorneys to consider on that case whether they want to have a sole rebuttal time. It'll still be 20 minutes total, but as far as how we want to divide that time, I'll hear from you and then make that decision. We will be taking a break after the third case. Any attorneys who wish to join us in the attorney lounge would be glad to be there with you and share coffee. If you have any electronic devices, cell phone, etc., make sure you put in the silent mode so the oral arguments are not disturbed. We'll go ahead and start with the case of Irving versus State.
Good morning. May it please the court, my name is William Pinnell and I represent Brian Irving, the appellant in this case. Please reserve 5 minutes of my time for rebuttal.
All right, you may proceed.
In this case, it's our position that the trial court erroneously denied claims 1 and 2 of Mr. Irving's amended motion for post-conviction relief. Initially, the trial court improperly denied the claim in which Mr. Irving alleged that his trial attorney failed to file a viable motion to dismiss the charges against Mr. Irving between the first and second trial. This was based on a mistrial that we believe the evidence shows was intentionally caused by the prosecutor in this case. And we would cite the Duncan case where the third DCA says that where a mistrial is caused by the bad faith prosecutorial or trial court misconduct, and it's designed to provoke a mistrial, the state is barred by double jeopardy from ever retrying the defendant for the same crime.
Counsel, doesn't your position conflict with the trial court's findings below?
It does, Your Honor. We don't think that the findings are supported by competent substantial evidence in this case for several reasons. As far as deficient performance, we believe that there was no viable reason or reasonable reason for trial counsel not to file this motion in writing.
Let's go straight to prejudice.
Okay. As to prejudice, we need to show that there was a reasonable probability that the trial court would have granted the motion to dismiss based on evidence that the prosecutor intentionally caused this mistrial.
And the trial court found that the prosecutor did not intentionally cause it.
And I would suggest that the evidence does not support that conclusion for a couple of reasons. First, the trial court found that the testimony of the prosecutor as to her intent and as to how she responded to how she asked the questions of the alleged victim and how she responded to the answer of the alleged victim, there's inconsistencies between her explanation at the time of the trial and at the time of the evidentiary hearing, which do not support the conclusion of the trial court that she was a credible witness. Initially, she states that...
So anytime a witness has inconsistencies, the finder of fact is required to find that they are not credible?
I think when the inconsistencies on the main issue before the court, it's inappropriate for the court to find her credible on that particular issue. The issue.
So what finding would the trial court make? The trial court would say, well, you're stuck with your first explanation. Is that sort of what the rule of law would be?
I think the rule of law would be that her explanation is not credible, and then the other circumstances in this case actually support a finding that it was intentional. If the prosecutor knew, as the alleged victim said in her deposition, that there was purported misconduct before the age of 6, and then she asks the question, tell us the first memory of when something like this happened, it's obvious that the victim is going to answer with an age that's outside the date of the information. So at that point, she's deliberately eliciting testimony outside the date of the information.
Okay, but you had the child had said 6 to the child protection team. The child had not been interviewed any other time. The child says 4 at the first trial. The attorney says, I believed it was 6 based on the only sworn statement or the only statement she had given. And the judge finds that, and then I understand later at deposition, the child then gives a different statement, says, I think I told the state attorney it was 5. And the state attorney says, no, the only one I was aware of, that never happened. The only one I was aware of was 6. How, are you suggesting that the trial court's belief that the prosecutor was telling the truth and that the child was mistaken was inherently not credible?
I am suggesting that, and I think that everything the court has said is correct, except that there wasn't other interviews. There was from the deposition, we know that the alleged victim had talked to the prosecutor numerous times before the first trial, and according to the alleged victim, during those.
But even, I mean, the alleged victim gave different.
I understand.
Child protection team 6, trial 4, post-trial deposition 5.
I think there was one indication in the post-trial deposition that it could have been 4 or 5, but when she affirmatively stated it was 5, which is certainly outside the dates of the information. But we know that
so you had the child given 3 different ages, and the prosecutor always maintaining 1. I mean, it seems like the inconsistency is in the child's statements, not the prosecutor's statements.
I understand the court's point. I think what's different about this case and what's important is that the prosecutor's explanation as to what happened was different. Initially, after trial, after the mistrial was granted, she says she didn't even notice that the alleged victim had given testimony outside the dates of the information. Now at the evidentiary hearing, she says as soon as she heard the child's response, she knew that was improper. So she's obviously both of those can't be true. So one of those times she's giving untruthful testimony. So I suggest that it's not uncommon for a child that, I agree with you that in the child protection team interview she said 6, but it's certainly not uncommon for a child to add or change their recollection as the case moves on, and there's no reason to believe that the child in her sworn testimony at the deposition wasn't being credible.
Is there anything in the record to support the idea that the state would have benefited from a mistrial in this case?
Well, there's substantial evidence of a benefit. Following the mistrial, the state expanded the scope of the prosecution. The second amended information had the earliest date of misconduct being when the victim was 6, and after the mistrial, they were able to file amended information with dates that corresponded with the victim's being 4 years old. They were also able to file a new Williams Rule notice.
So are you suggesting that, under your theory, the prosecutor knew that the incidents allegedly happened when the victim was 4, and that the prosecutor intentionally elicited that testimony about the victim being age 4 in order to get the mistrial so that they could amend their information? Is that essentially your position?
That's one of the reasons. The other reason is to file the Williams Rule notice that was stricken before the first trial. There was a Williams Rule notice that was filed shortly before the first trial that was stricken because it wasn't filed more than 10 days prior to the first trial. A week after the mistrial, the prosecutor refiled that and was able to proceed on that. So there's a direct correlation between the mistrial and being able to refile this Williams Rule notice, being able to amend the information to include a larger time frame. And the prosecutor herself at the evidentiary hearing says that she knew a mistrial would be caused if she knows that if you elicit testimony outside the scope of the information, that's likely going to result in a mistrial. So I believe that the totality of the evidence, including the inconsistent statements, and they're directly contrary from the prosecutor as to what she was thinking at the time she...
But at the time the state did the initial information, and they alleged a time frame that would have started when the child was 6, they would not have known that the Williams Rule notice wouldn't have been stricken. That was filed 10 days before. So
But at the time of the
if
trial...
they had known it was 4 years old, it would have made sense to file the initial information, with the expanded time frame. Now, I understand your argument that the state benefited because they got 2 Williams Rule witnesses in that they wouldn't have otherwise. But if you go back to the initial information, it seems like they were under the impression that the acts occurred, not before the child was 6, because there would have been no reason for them, if they thought it was age 4, not to file that information going back 2 years at that time. Because they wouldn't have known the Williams Rule notice that they didn't file till a week before trial would have been stricken.
But I think the relevant time period is the time of the trial where they asked the questions. At that time, they knew that the Williams Rule notice had been stricken. So now they knew that they were handicapped or disadvantaged because the Williams Rule notice had been stricken. So now there's an incentive to get a mistrial so they can refile that Williams Rule notice 10 days prior to the second trial. And that's what they did.
I'm kind of going to the first issue that also suggests the prosecutor was telling the truth when she said, I thought the first incident was when the child was 6, because there would have been no reason to file the information otherwise.
Which information? I'm not
The
sure.
initial information.
Well, this is after the mistrial, so they filed the amended information after the mistrial.
But the initial information was filed assuming that the first act was at age 6.
Okay, but so a reasonable possibility is that the original information, the second amended information, was filed, and then went after the CPT interview where the alleged victim says it's 6, and then there's pretrial discussions with the alleged victim in anticipation of trial, as the child victim says during her deposition, and that's when she tells the state attorney that this started when I was 4 or 5. And then she goes to trial and asks these questions, and she says,
But counsel, aren't you kind of speculating there? Where in the record is that established? I hear what you're saying, right? You're saying, look, they might have found out right before trial when it was too late to amend the information. But isn't that a big might? Maybe they found out right before trial?
Well, the second amended information is filed, a substantial amount of time before before the first trial. The alleged victim in her deposition says there's discussion about prior to trial. So I don't know that it's a might, and I also want to point out to the court that we don't have to establish today that 100% that this motion would have been granted. We're talking about the prejudice standard, not deficiency. We have to show a reasonable probability. That's defined in Strickland and in Spicer from this court as not even as high as more likely than not. So not even 51%. We just have to show sufficient to undermine the confidence in the outcome here. So we have to show some chance that the motion would have been granted. Not more likely than not 60%, maybe 30, 40% under the prejudice standard. And I think that given the sworn testimony, the most recent sworn testimony before the trial, that she told the state attorney, when combined with the questions that were asked, suggests that the prosecutor did know. And so the prosecutor asked the question, when was the first time this happened? And we would argue that, given the child's testimony at the depot, that the prosecutor knew it was 4 or 5. But even
I understand why you're doing that. You keep relying on the victim's testimony at the deposition, and I understand that. But as an appellate court, it's not our job to sort out the facts, right? So you have the child in the depot saying, oh yeah, I told the prosecutor, and then you have the prosecutor at the evidence you're hearing, impeached or not, right? But saying, no, I had no idea. That was the first time I heard it. So how would we, and you're suggesting, well, look, because the prosecutor was essentially, had inconsistent statements, right, that we sort of write a rule of law that says the trial judge cannot find the prosecutor credible in that circumstance. How do we write that? What does it look like?
On the essential issue before the trial judge, in the Rule 3850 hearing, the prosecutor was not credible. Like,
Anytime there's conflicting testimony from the prosecutor.
oh, and they're directly at odds with each other. They both can't be true, so she's not being truthful in one of those instances. And then the Duncan case citing
Did the prosecutor previously say, hey, look, she told me that she was 4 the first time, and I just asked the question anyway? Did the prosecutor ever say that?
No, she said that I didn't even realize she said 4, and then at the evidentiary hearing, she said, I realized it immediately. So those
She
are,
realized immediately that it was outside the information.
right, but at first...
Not that the victim had previously told her that.
Correct.
Right.
Correct. So if you read the Duncan case, which relies on the Oregon versus Elstad case from the U.S. Supreme Court, they talk about you don't need an admission from the prosecutor. You just need to consider all the circumstances. And it's our position when you consider all the circumstances, including the initial question and the fact that the prosecutor doesn't stop when she says I'm 4. She says, quote, tell me about it, suggests that she knew what was going on, didn't correct herself, and moved on with the intent to cause a mistrial. So it's our position under the totality of the circumstances, including the specific questions that were asked, including the child's deposition, that the court should conclude that this was unintentional and that the prosecutor was not credible. And
Counsel, this comes down to a credibility determination. You agree with that?
Partially.
I mean, a big part of this is credibility, right?
Sure.
This panel has no way to judge the witness's credibility, correct?
Well, a factual finding of credibility has to be supported by competent substantial evidence. I think when the prosecutor is giving diametrically opposed statements about a vital issue in the case, that finding cannot be sustained.
All right. You're a little over 5 minutes.
As to the second issue, we'd argue that the circumstances of the case, including 3 child victims, the defendant's minor child, the defendant's half-sister, and the defendant's ex-wife's sister, were all prepared to testify that he committed sexual misconduct against him, that it was completely unreasonable for the defense lawyer to advise him that there was a 50-50 shot or he had a reasonable chance to win under the circumstances of this case. The only reasonable advice would have been accept a 10-year plea offer when you're facing a mandatory life in prison. So it's deficient performance by failing to advise and recommend that he accept a plea offer under Lafler from the U.S. Supreme Court and the Florida cases that follow, and it's prejudicial because there's a reasonable probability that Mr. Irving would have accepted that plea offer had he been properly advised by his attorney. And I'll reserve the rest of my time for rebuttal.
All right, thank you.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. This is a credibility issue. This court cannot make a rule that if witnesses aren't saying the exact same thing 5 years later, we can't find them credible. That's absurd. That would be an impossible standard to meet.
Would you agree the state benefited from the mistrial by being allowed to put on 2 Williams Rule
The state benefited
witnesses,
in,
which they otherwise would not have been able to do?
well, the one witness came out after the mistrial. The state didn't know she was going to say that she had been molested too. I'm not sure if Ashley, the other witness, would have been introduced at the first trial or not. I don't think
The state
records
did a
would
Williams
confirm
Rule notice, but it was untimely.
Yeah, but the
judge
state, but the
struck it.
Williams Rule notice that was stricken
Right.
was about the victim. It wasn't about, it was filed in what she called an abundance of caution. It's on page 690 of the record. She filed it saying that we're going to introduce other incidents of the defendant touching this victim.
We don't know.
And they use the same dates.
Yeah, we don't know what the state's knowledge was of these other witnesses, but would it be fair to say they were able to call 2 witnesses for the second trial that they were not going to be able to call the first trial?
It would be absolutely fair to say that they could called Danielle after the second trial because she came out with her story after the first trial, after the mistrial. I'm not
Your
exactly
point is
sure what
that
the
they
deal is
didn't,
with Ashley.
your point is they didn't know they were going to
They
be able to
didn't
do
know they
that
were
at the
gonna
time of the mistrial.
Exactly, yes. This Williams rule notice it didn't strike another witness. She filed it, I don't understand why, saying, just in case, I guess, the victim started talking about something that hadn't been disclosed previously. She even used the same dates that were in the information. Even that Williams rule notice doesn't
There are
include
two Williams rule
earlier
witnesses,
things.
right?
Before the first trial,
No, before, that testified at the second trial.
2 Williams rule witnesses testified at the second trial.
Okay.
I
Was the
don't-
state aware of either of them?
I
You
know
said the
that-
state was not aware of one. Was the state aware of the other one before the first
I
trial?
don't think that's clear in the record.
Okay.
If she would have been in the first trial or not. I don't think that's clear, but we know that Danielle came out with her story after the mistrial. But again, the prosecutor had no way of knowing that was going to happen. The trial judge at the time of the mistrial found the prosecutor's explanation credible. Defense counsel said, charge this to the state, bar it by double jeopardy, and the trial judge, who was there when the witness testified and saw the prosecutor's reaction and saw defense counsel's reaction, said, I believe the prosecutor. She didn't know this. She was surprised. That's not goading the defense into a mistrial when you don't know that the witness is going to say that. These are kids. Kids and dates are never a good combination. They're always all over the place. And after the mistrial, the victim was deposed and said, yeah, I told the prosecutor about it. I told her I was 4. I also told the child protection team that I was 4. I just watched my video and I said 4. That's not true. She was mistaken about the dates, which is very, very common with children, especially young children like this. So he can't possibly show prejudice. Because this doesn't undermine confidence in the outcome when that motion would have been denied because they believe the prosecutor. She argued it. The trial judge made a factual finding. The prosecutor testified at the hearing, said something slightly different, said, yeah, I realized it was a problem, but I wanted to move on because the cow was out of the barn, so to speak. I didn't want to draw attention to it. At the trial itself, she said, I didn't even realize it. I was just focusing on my next question. Those aren't, diametrically opposed. She didn't say, yeah, I kind of had a feeling that kid was going to say the wrong age, but I thought I'd give it a shot. She never testified like that. And even that, under the case law, isn't intentionally goading. That's a high standard because the defense moved for a mistrial. The state didn't move for a mistrial. They wanted to keep going. The defense moved for it.
Counsel, what about failing to advise the defendant to take the plea, the other claim?
The other claim,
I mean, you're facing, 2 Williams rule witnesses,
Right.
I think that the trial counsel at the evidentiary hearing conceded that she was not aware of any case where you prevail when there's 2 Williams rule witnesses, I believe is what she said. Maybe I'm wrong.
I think she said she wasn't aware either way, yeah.
Right. So you're looking at 2 Williams rule witnesses. I believe they were both relatives. Was counsel ineffective for failing to affirmatively advise, right?
To
the
take the
appellant?
plea. No, and here's why. The defense in this case was that this was all the product of a divorce, that the ex-wife was driving this, getting the kid to make up the story. It was apparently a very ugly divorce. These were family members who had disclosure issues. I mean, they disclosed years and years after the abuse took place. Danielle came forward after the first trial. She disclosed so late. Defense counsel went up and met these witnesses in person because she said, I needed to see them to see if they were credible. They did not appear to be credible to me. And her advice was, look, you never know what a jury is going to do, but I know that you say you're innocent. It's up to you whether or not to take the plea. It's a 50-50 shot. I'm going to impeach them. I'm going to do my best. But you never know what a jury's going to do, and this decision is yours. That is the exact right
And there was no
advice.
physical evidence, right?
No
I mean,
physical evidence and no admissions.
It was all witnesses.
It was all witnesses, and, in these cases, These are kids who are testifying years later, and they're all over the place all the time. It's always a risk. You don't know what a jury's going to do in these cases because it's little kids up there testifying. You don't know what they're going to say. You don't know if the jury's going to believe them, and that's exactly what she told them. She took the depositions. She said, I think I can impeach them. I don't think they're credible, but you never know what a jury's going to do. The defendant admitted, I knew that this was a life case.
Let's say that, you have this case, but, then let's throw in, an admission that's recorded or maybe some physical evidence that's difficult to dispute, right? If you had one of those things plus the Williams Rule evidence, at that point, are we sort of ineffective? Does the lawyer have to affirmatively advise at that point?
That's a closer case. It's not what we have here. I would argue that it's always the client's decision, but you have to give correct advice. If she had said, don't take this plea, we're going to win at trial, that would be tough to defend. But she just said, here it is, you don't know what a jury's going to do, we have this defense, you say you're innocent. It's up to you because we don't know what's going to happen, but I'll do my best. He didn't want to even counteroffer for a probation sentence. He did not want to take a plea. And let me note that the judge made a factual finding that the defendant did not establish that he would have taken the plea. The best he could come up with when he's being led at the evidentiary hearing was, I probably would have if I had been cornered. That's not enough to satisfy the Lafler standard. He has to show I would have taken the plea. And he wouldn't even say that now when he's sitting in jail for the rest of his life, and he won't say this. This defendant maintained that he was innocent. The defense counsel testified she believes he's innocent. She still believes it now, and she's a prosecutor. She did not believe these witnesses. The jury did. She told him you'd never know what the jury's going to do. I would submit that she gave the exact correct advice. He knew it was bad. He testified to that at the evidentiary hearing. He knew that having multiple witnesses is not a good situation. But there's no DNA. There's no admissions. We have an ugly custody dispute and a whole family thing. There were injunctions. I mean, it was not a kind divorce. Those are the situations where I would submit a defense attorney is reasonable in believing that he can persuade a jury that those kids are not telling the truth, given, they disclosed it years later, which is always a little suspect. It's not like there was no defense. It's not like there was a videotape or he confessed or there's DNA in her vagina or anything like that. So she told him it was up to him. And she told him, here's what's going to happen. If it goes bad, you're going to be in prison the rest of your life. And he decided not to take it, and that's always his decision. So I'd submit she gave very good advice. If she had told him to take the plea, and he had, I think we'd be here with him saying she incorrectly advised me to take this plea. They're in a bit of a catch-22, but it's always the client's decision. And she told him exactly what the consequences were, the strengths and weaknesses, and that's the best an attorney can do. If there are no other questions, I would ask you to affirm.
All right, thank you.
May it please the court. Certainly, it's the client's ultimate decision, but the case law, Lafler and its progeny, say that you have to get reasonably competent advice from your trial attorney as to the strengths and weaknesses of the case. And it's our position with 3 minor victims testifying, including the defendant's natural daughter, who by the time of the second trial would have been testifying to conduct that occurred when she was 4, his half-sister, and the sister of his ex-wife, that the trial attorney's advice that there was a 50-50 shot you were going to win this is unreasonable.
But the trial counsel went and evaluated these witnesses and concluded that they weren't credible. I mean, how do we conclude that was as a matter of law incorrect? I mean, how do we reevaluate that Monday morning quarterbacking it?
Well, the defense lawyer testified herself during the evidentiary hearing. In her 12 years' experience as a prosecutor and a defense lawyer, she had never seen an acquittal with 2 Williams Rule witnesses in a sex case. And she's an experienced lawyer on both sides who's handled sex cases on both sides. So
wouldn't we have to just say as a matter of law, if there's 2 Williams Rule witnesses, as a matter of law, you must advise your client to take whatever plea offers given?
You certainly can't tell them it's a 50-50 chance. Sex cases by nature are difficult. It's readily apparent that lay members of a jury are going to feel sympathy for a child. Now you'd have 3 children testifying. So to suggest that a 50-50 analysis is reasonable under these circumstances, given the defense lawyer's testimony, experience, it's simply unreasonable. And the trial court's finding didn't find that Mr. Irving was not credible. The trial court found that he was equivocal. I'd suggest that that's not supported by competent substantial evidence as well. When you read the defendant's testimony about whether he would have taken the plea had he been told that he had a good chance of being convicted and getting a mandatory life sentence, he testified, if I would have been cornered, then obviously my outcome, my choice would have been different. He says on cross, his hesitancy is he doesn't want to admit guilt because he believes he's innocent, but had he been told that there was a good chance he was going to get convicted, he would have entered a guilty plea. So I don't think it's equivocal. I think the defendant was sharing his thought process that he was reluctant to enter this plea because he was innocent, but if he would have been forced to do so based on the proper advice of his lawyer, he would have done it. It's the equivalent of going to the doctor. The doctor tells you, we need to cut off both your legs, otherwise you're going to die. You're not going to be excited about that. You're not going to unequivocally say, do it. You're going to think about it. You're going to be like, I really want to walk. I don't want to go to prison for 10 years. But when it comes down to it and you say you're going to die, you're going to cut both legs off. So what you see in the testimony is that thought process from the defendant that I really don't want to go to prison for something I didn't do.
In your view, what should the trial counsel have advised? Give me the exact advice.
Mr. Irving, you're facing a mandatory life in prison. I think it's extremely
Well, she said that part, right?
Yes. It's extremely likely you're going to get convicted when we have 3 minors testifying that you abused them. I think that under these circumstances, I recommend that you take the 10 years because it's too big a risk, given the likelihood you're going to be convicted.
So she should have said it is extremely likely?
Yes. I think that the court and any rational person who's had any experience reading transcripts or presiding over a child sex case knows that it's almost impossible to win when there's 3 child victims testifying against the defendant. So the advice of counsel was unreasonable in this case, and the court should reverse the trial court's decision.
All right, thank you.
Thank you.